In this video, we're going to talk about inherited IRAs and the Secure Act and the 10-year rule and what particular rules might apply to you if you are a beneficiary of an inherited IRA. Let me start by saying that it used to be that you could inherit an IRA from somebody who had passed, and you would be able to what's called stretch that IRA, the distributions out of it over the course of your lifetime. So that used to be really awesome for people who died when they were 80, gave their IRA to somebody who was 50, who was likely to live also until 80 because they could take the distributions over time and stretch the growth of that IRA and the distributions from it over 30 years or however much longer they're going to live. And that was a really beautiful thing, and we called it the Stretch IRA. What the Secure Act did for beneficiaries who are non-spousal, aren't within 10 years of age of the person who died, and some other categories, is they eliminated that Stretch IRA. That is gone. So this idea that you are going to inherit an IRA and you're going to stretch it over the course of your lifetime actually no longer exists. It does for some categories, spouses, disabled people, etc. But for those of us, and this is really who this video is directed at, who inherited an IRA from mom and dad and now have to make some decisions about what to do with it. The Secure Act put a line in the sand. So I am going to be talking about really those folks who inherited an IRA from somebody who died on January 1, 2020 or later. If they died before that, old rules apply. You can still stretch that out over your lifetime. But for those who have a loved one who died after January 1, 2020, you're not going to have that benefit anymore. What is now in place is what's called the 10-year rule. So if you inherited an IRA after 2020 and you are a non-designated beneficiary, then you are now subject to what's called the 10-year rule. So just so that you understand, what the Secure Act did is it split beneficiaries. It used to be everybody was sort of lumped into one group of eligible beneficiaries, and now you've got two groups. And that's really what's happened here, is you've got eligible now and non-eligible designated beneficiaries. And so really the focus of this video is those folks who are non-eligible designated beneficiaries, because more or less the old rules are going to apply to an eligible designated beneficiaries. So really what happened with the Secure Act is that the designated beneficiaries were split into two categories. So now there is an eligible designated beneficiary and a non-eligible designated beneficiary. And that's really the group of people that I'm talking to today, is those non-eligible designated beneficiaries. What I want you to realize is a couple things. Number one, the Secure Act was passed in the very last days of 2019, right before the whole COVID epidemic. So a lot of us were highly distracted during that time and probably didn't realize this rule was coming to pass. If you were not aware of this, don't feel bad about that. But let's talk about what happens next. So if your loved one died after January 1, 2020, and you have now inherited this IRA and you are a non-eligible designated beneficiary, which is most non-spousal beneficiaries, and some see through trusts. I'm not going to get into the nitty-gritty details of that, but talk to your tax person and your financial planner about what category you might be in. But right now, we're just going to talk about your non-eligible designated beneficiaries. Classically, mom or dad has passed and you've inherited their IRA. Okay, and they've died after January 1, 2020. You are now subject to what's called the 10-year rule. You need to deplete that account by the end of 10 years. And I often get the question, well, why in the world would Congress pass such a thing? And it's because they want to get that money out of a tax-deferred environment and into a taxable environment. This 10-year rule applies whether you have an inherited Roth IRA or an inherited traditional IRA. It does not matter. That account has to be depleted at the end of the 10 years. Now, while you're taking money out of the Roth, you're not going to be taxed on it. And even if you wait and deplete it in year 10, then you're not going to get taxed on that either. But arguably, that money goes back into the investment system, and now it is in a non-qualified, in other words, a non-retirement account, and now there's going to be gains and losses, and there's taxes that can get collected on that account. So that's why this is happening. The government is really just trying to raise money. So again, whether you've inherited a traditional IRA or a Roth IRA, you are now subject to this 10-year rule. And here's what that means. It means that you must deplete that account within 10 years years after the year in which your loved one died. So if you had a loved one that died in 2021, you need to deplete that account by December 31st, 2031. Okay, those are your 10 years. I'm going to talk in a minute about how to plan for that, but what I want to make sure you understand right now, and I'm doing this video at the beginning of 2025, the IRS did not issue guidance about whether or not you had to take what's called required minimum distributions during this 10-year period. And so nobody really kind of knew whether or not they had to take what's called an RMD, or known as the RMD, the required minimum distribution, for 2020, 2021, 2022, 2023, 2024. And then in the middle of 2024, the IRS came out and said, if your decedent, the person who died, was already taking their required minimum distributions when they passed, then you, as the person who inherits this IRA, needs to also be taking the RMDs during that time. This video is really directed at those of you who have mom and dads that passed, that were probably in their 70s and their 80s and 90s, and they were taking their RMDs. And now that you've got this IRA, you're going to have to take these RMDs. Do not freak out. The IRS has said that if you did not take an RMD between 2020 and 2024 for those years, you are not going to be subject to any penalty, which all of us have decided means that you didn't have to take the RMD, which in many ways has been a beautiful thing because there's likely been a lot of growth in those accounts. However, starting in 2025, you will be required to take that RMD based on your life expectancy and that calculation every year from now until that 10th year, when you are still going to have to deplete the account. So let's just use that example that I was using before. Let's say your loved one died in 2021. You've not been taking RMDs. Your loved one was taking an RMD when they passed. You are now going to have to take an RMD in 2025, and you are still going to have to deplete that account come 2031. So pay attention to these particular requirements and whether or not your loved one was probably making an RMD payment. And again, this video is really directed at those of you who most likely are going to have to take that RMD. And then you're going to have to deplete it at the 10-year mark. Okay, what is also true in these accounts is that during that 10 years, despite whether or not you need to take a required minimum distribution, an RMD, starting in 2025 or not, you have some flexibility as to when you take the money out of this account. And the traditional thinking is you leave it in there and you leave it alone because you'll get growth on it, and then you can go ahead and withdraw it at the end of the 10th year. That is certainly a possibility still, so that's one option. Another option is that you take withdrawals along the way and you spread out the distributions over those 10 years. And then there's also an option that you can strategically make decisions about what year you take distributions. Aside from the RMD, you have the option to take big chunks in some years and smaller chunks in other years. You can make decisions strategically based on your particular tax situation, whether or not you want to take those withdrawals. So those are your three options. You can leave it alone until the end of the 10th year and then withdraw it all. Again, RMDs aside. You can spread it out evenly over those 10 years, or if you want to count the year of death, even 11 years, or you can strategically just take it out in those years that it makes the most sense. How do you make these decisions about when to take the money out? First of all, I think it matters a lot whether it's a traditional IRA or a Roth IRA, because if you take money out of the traditional, you are going to have a tax implication. If you take the money out of the Roth, then you do not. What your particular tax situation may be is really what's going to drive this decision, because if you're in a high income year and you add a withdrawal from a traditional IRA, even an inherited IRA on top of that, then you're going to have even more taxes to pay on it. And so oftentimes it makes sense to wait for perhaps a low income year, or maybe it's a year that you actually plan to quit working for a paycheck. And so you just don't have as much income in that year. Whatever the situation might be, it might actually make sense to wait for those low-income years to come around and then take bigger distributions from that IRA. I think a lot of people, when they think about, okay, well, I'm just going to let the money sit there and let it get as big as possible. Well, 10 years out, I mean, that the money in there could have easily doubled. And if that's the case, now you've got a year where you're taking out all of that money, and again, not the Roth, but the traditional IRA, now you're going to have to pay taxes on all of it in 1 year. And that could throw a big chunk of money into your highest tax bracket. And so it often doesn't work to your benefit to be leaving that money in there for the 10 years and taking it all out at once. Some people do like to spread it out. I think the high side of this is that there's some predictability to it, especially if you're relying on that income for something. And it just allows that money to grow, and you're slowly but surely getting the money out of there so that come the 10th year, the account is depleted. So lots of different ways to do this. Talk to your tax person. I want you to talk to your financial planner. I want you to look at what your cash flow needs are in your own particular situation. And then also just look at, what do you want to do with this money? What's important to you? What are your values around it? I mean, I have a lot of clients where that particular aspect actually influences what we do in terms of withdrawing money from these accounts more than anything. The other thing that I want you to be mindful about is that you need to identify a beneficiary on your inherited IRA. So you inherited this IRA from, let's say, mom or dad, and they made you the beneficiary. Now you are the account holder, and now you need to name a beneficiary. And there's lots of things to consider when making that decision. But what I want you to be mindful of in just this moment is that when you designate that beneficiary, and let's say you die before the 10 years has passed, the person who inherits this inherited IRA of yours is actually subject to the same 10 years. So let's play that out. Let's say your loved one died in 2021. You inherited this IRA. You designated, let's say, your kid as your beneficiary, and let's say you die in year 4. Well, your kid now takes on this IRA, and it's an inherited IRA for that person, but that person now needs to deplete the account within 6 years. So just be mindful that who you pick as your beneficiary and what that's going to look like and what the implications of that are. It might make more sense to name a spouse. That person's also going to be subject to the 10 years that got started when you initially inherited this money. So there's just a lot of things to consider, and you want to be mindful about what beneficiary that you choose, and then how that beneficiary designation is written so that your wishes are honored in the process. Naming your revocable living trust may not be your best answer. And most of the time, I would go so far as to say IRAs really should go to human beings rather than to trusts. But this is something you want to discuss with your estate planning attorney, your tax professional, your financial planning professional. So I'm going to do a cursory review of this just for the moment, but now there are strategies for account owners that they can implement, or things that they need to be thinking about. Let's just say it that way. Now that the stretch IRA is essentially gone, it might be that maybe they want to increase the number of beneficiaries so they get to spread that rule out over a wider variety of people. They might want to now give more consideration to the tax implications of their particular beneficiaries. They might have one kid that makes a whole lot of money and another kid that doesn't. And it might make more sense to give the kid that doesn't make as much money the IRA, and maybe give the kid who makes a lot of money a different asset. So there's planning around that needs to happen. It might make sense to not have the spouse be the primary beneficiary and go ahead and let that spouse either disclaim that gift or not be named as a beneficiary, and move that IRA to other beneficiaries where it could just be more beneficial given this 10-year constraint. It's also worth it to now start taking a stronger look at Roth conversions, maybe even having the folks who are going to be the beneficiaries help the account owners with the tax implications of a Roth conversion to make it more beneficial when that person dies to pass those assets along. There's also strategies around life insurance that we can consider to get more money into the hands of beneficiaries and have that money arrive income tax free. There's also a variety of strategies with charitable remainder trusts to put that money into a trust and have that trust kick off income to a beneficiary, much like it would have happened with the stretch IRA. Has a lot of other considerations that need to go into that, but there are now very different planning opportunities that have to happen for these account owners because the stretch IRA is now gone. May this video have been helpful for you to understand what's going to happen if you have inherited an IRA for somebody that has died after January 1, 2020. Hope you understand now that you need to take an RMD most likely in 2025. That's what I'm planning for my clients at this point in time. That you have some decisions to make about leaving it alone or taking out even distributions over the time, or strategically taking distributions when it makes sense for your particular situation. And I will just reiterate again, it's so important to talk to your tax professional, your estate planning professional, your financial planning professional to help you make these decisions so that you can just do the best thing by yourselves and your family and make best use of this money that has come to you. I'm sorry if you've lost your loved one. Now you have this money and you have the opportunity to do something with it that and perhaps honors their memory as well. I'm Jessica Lanning. Lanning Does Planning.